It was a self-defense case.
No. Let me stop you right there.
Okay.
So with regards to your, no. Here's the thing. With regards to self-defense, you're charged, according to this, with assault, family violence, choking. Adrian Garcia. All right. Today's plea deadline date is, have y'all reached an agreement, or is this going to be a jury trial?
It's going to be a jury.
How long do y'all expect this to last? Norm, I need a jury trial date, 3 days.
Since the day I got arrested, I was whisked away in the cop car. I spent 4 months in jail, not talking to anybody. I barely spoke with my lawyer, but twice, less than 25 words, both court dates. I've seen him talk to the district attorney. Even less words than that. So I just want to be heard, Your Honor, that it was a self-defense case.
No. Let me stop you right there.
Okay.
So with regards to your, no. Here's the thing. With regards to self-defense, you're charged, according to this, with assault, family violence, choking. Yes. So with your attorney and his conversations with the state, maybe he's received all the information he needs to receive from them. For him to say that you're requesting a jury trial means that an offer has been tendered and you've made the decision that you do not want to accept the state's offer, and there is no agreement that's been reached. Is that correct? I don't want to know what the offer is. My only question is,
I just want to be heard, Your Honor.
could you tender him the offer, please?
Yes.
So he's gonna continue to offer, then you can let me know whether or not you have accepted the offer.
I don't mind going at the bottom. I'm very confident.
All right, then we're going to give you a jury trial date.
Thank you. I just want to be heard that I think I would be better off in probation, not because I think I'm guilty, but because.
But let me ask you this. And let me explain something to you. Number one, what you've been charged with, and I don't know anything about your case. The only thing I know is what's in the indictment. Wait a minute. All I know is what's in the indictment. What's in the indictment is they're charging you with assault, choking. Now, normally assault, choking, family is a 3rd-degree felony. They're proceeding on you as a 2nd degree. So that means that they're saying that there's something else that they're alleged that's in your past. Either what's in your past is another family violence case, or either they're enhancing you because you've been to prison before, right? Now, with regards to making this a 2nd degree instead of a 3rd degree, if there's a jury trial, or if the state has to prove that, your attorney probably has already told you that's proved with documents. Whatever that case is, there is normally not a retry of that case. For example, if somebody's been to prison and the state wants to use the fact that they've been to prison to bump up their range of punishment, that case doesn't get retried. All they do is bring in what's called a pen packet. They present it to the jury, and they have to prove that that pen packet is actually yours, and they bring that to a jury. And then with the case, whatever you're on for, that's a part of the indictment that they're accusing you of. For example, with assault, family choking, of course, they need a complainant. That's the person who's saying you did this. Then they need that person. They need an on or about date, and they need somebody to say it was you. And then the jury will hear that evidence, and the jury will make a decision on whether you're guilty or not guilty. Whether or not you believe you deserve probation or not, that's your belief. If you go to jury trial, if the state are able to prove what they're able to prove, and I don't know what that enhancement is or how they come by that enhancement, based upon that, you may or may not be eligible for probation from a jury. But whether or not you tell your side of the story or whatever, that depends on you. You have a right to testify or not testify. The state can't call you as a witness to testify, but it appears that you all are at an impasse. It appears that you want probation. It appears the state is not offering probation. So your plea deadline date has expired and you will be set for jury trial. And you all think this will last 3 days? Miss Ferguson, I need a 3-day setting for a jury trial, and counsel, if you'll do acknowledgement of discovery. Judge, it could be February 24th. I need it in January. We can do January 15th. You say 13th? All right, your jury trial date is going to be January 13th. You're going to be brought over in whatever civilian clothing you have at the jail. If you wish to be attired in something different, there'll have to be a clothing exchange. Counselor, the new rules at the jail is that the clothing exchange must be requested within 72 hours of trial. So you can't do it 2 months in advance, or you can't do this in December. It'll have to be exactly 72 hours.
I have to request this clothing?
If he wants to do a clothing exchange, you have to file it.
Yeah, I mean, my shorts are torn because my son Fisher would do it.
Oh, okay.
Okay. All right. Thank you. Who's next? Miguel Contreras. Hi, how's it going?
Good, how are you?
All right. Are you all ready to proceed on the MTR?
We are, Your Honor.
Court is calling 2024 CR 012263, State versus Miguel Contreras. Can I have parties announced for the record for the state?
And Lauren left in for Mr. Contreras.
All right. And are you Miguel Contreras? Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same Miguel Contreras Jr. who's placed on deferred adjudication in 2024 CR 012263 for the offense of evading arrest detention with a previous conviction on January 23rd, 2025 for a period of 4 years? Is that you? All right, state.
Petition for order and their county practice defendant Miguel Contreras Jr. did then and there fail to report supervision officer as directed for the months of July and September 2025 violation of condition number 4.
How do you plead to that? True or not true? State. Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 4? Court will find violation of condition number 4 true. Is there a proposed agreement?
There is.
Yes, Judge, any court to deny the state's motion as alternate amendment conditions for mental health.
He's not to interrupt, but he's already completed his mental health. So the agreement was for him to do the outpatient dual diagnosis intensive program. Is that correct?
Judge, the recommendation and agreement is for him to be placed on the mental health initiative caseload and for him to complete the dual diagnosis outpatient program.
Thank you.
All right, thank
Nothing
you.
like that.
All right, you want to raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand. State your name for the record. All right. So what has been going on with you?
I was saying to my brothers, but it didn't work out there. Well, with them getting like a power attorney over me or whatever for helping me with this.
All right. So I'm going to give you a choice. I don't know if you'll be successful on this probation or not. My hands are sort of tied with the different programs that I can have available to you because there's a lack of funding. There's a lack of placement. Now, I can follow the agreement that has been reached, or I will sentence you to 8 months in the state jail facility. So do you want me to follow the agreement?
Yes, please.
Okay. So the court will deny the motion, alternate amend conditions to include MHI plus outpatient treatment with dual diagnosis. And Miss Abrams, because there may be issues with him, can you make sure that they do the field visits? And so there'll be field visits one time per month until further notice. And we're doing the field visits to make sure that you stay in compliance, okay? I want you to be successful at this.
And I don't know if the court could order, but I did tell him to ask for employment resource or help with that, as well as housing assistance.
All right. So employment resources and any housing resources. And there is a program, I want to say it's called Build Back Brighter, something of that nature. They can help with housing as well. They're a nonprofit, but they may be able to help you.
I'll Google it and maybe write the information down.
All right. Thank you.
Okay. Thank you, Judge. May I be excused?
Yes.